Good afternoon and welcome back, ladies and gentlemen. Our next speaker, I haven't brought my notes with his biography because our next speaker very sincerely needs very little, if any, introduction. Many of you have come here particularly for this topic itself, but also because of the Honourable Michael Kirby, former Judge of the High Court, former President of the New South Wales Court of Appeal, former foundation member of the Australian Law Reform Commission. His Honour is talking this afternoon on the issue of discrimination. His Honour, again, like I said, I probably need to introduce him no more. Please join me in welcoming Michael Kirby.
Thank you very much, Luke, and thank you for having me at this seminar. Thank you all for getting back on time and being here, ready and roaring to go. And I'm going to talk for about half an hour, hopefully a bit less, though it's very hard for lawyers to speak for a very short time, as you know. And then we will have some questions. I acknowledge the traditional custodians of the land sincerely and with respect, as the New Zealanders do. We have to learn to be better and more reflective in respect of our links and our debt to the Aboriginal and Torres Strait Islander people. I also acknowledge the Salvation Army for the wonderful work that the Salvos do, and I acknowledge the work that Salvos Legal perform with Lou Geary and his colleagues, and including in the field of discrimination and social disadvantage. Isn't that a wonderful word behind me? And I heard how it came about, just one word in the telegram, and the word was to think about others, and that's what we should all be doing. I acknowledge the presence of the Honourable Murray Wilcox and the Honourable Kevin Lindgren, great Australian judges, and also teachers and law reformers, and I am very proud to be here with them. We are part of the mothball fleet of ex-judges, but we still have life and energy within us and a passion for justice. Justice according to law, but justice is the banner under which the legal profession marches. I have spoken in this hall once before. I came here at the invitation of Luke Geary and of the Salvation Army, and the story about my speech on that occasion is told in a wonderful best-selling book, which is the book of my life, and I just happen to have a copy of it with me. Michael Kirby, A Private Life, and the third last chapter is the Salvos, and it tells the story of how I came along, how I was invited, how then when I indicated I was going to talk about sexuality, I was de-invited, but then how I protested and appealed to their Protestant sense of conscience and individual expression, how I was then re-invited and greeted most warmly, and how I had wonderful questions from the audience, as I hope I will have from you today. In most matters of discrimination, and in the area of discrimination on the ground of sexuality, we're all on a journey, including myself, and therefore it's appropriate that it should be a respectful journey, and that people should respect the fact that not everybody is at the same point of the journey, but that we can learn from each other by listening, learning, thinking, feeling about others, and doing so with real love, which I think is at the heart of all the great religions of the world, and certainly my understanding of the Christian religion, and most certainly my understanding of the Salvos, who do such loving work for the disadvantaged in society. Now, it was inevitable that I would end up as a person who didn't like discrimination. My life was really a teacher for me of how wrong discrimination is. And it all began back in the 1940s. I went today to speak to this morning to the public defenders at the zoo. It's a long time since I've been to the Taronga Park Zoo. They have a convention centre there, which I have been to before, but not for a while. And it's a magnificent place, and all the public defenders were there, and I spoke about recusal and incompetent counsel. So I won't talk about that to you, because you all look very, very ferocious and competent. But my first entry in my ASIO file is an entry telling the story of how my grandmother's second husband, Jack Simpson, was seen at the zoo with 3 young boys. And he was the national treasurer of the Australian Communist Party, which in 1948 was not a good career move. He'd served in Gallipoli and on the Somme. He won the Military Cross. He was a wonderful man. He threw away his medals, and his religion, in a sense, became communism, but a very idealistic man who we knew personally. And as you know, in 1950, the Parliament of Australia, with the support of the people at the election that returned the Menzies government, introduced the Communist Party Dissolution Act. It was enacted. It's still there in the statute book, if you look, the Communist Party Dissolution Act. And it was designed to dissolve the Communist Party, to confiscate all their assets and property, to round up people who promulgated the communist banner, and to deal really nastily with them. And I knew that something awful was happening to this man who was part of my family. And then in 1951, I knew that this strange body in Melbourne had somehow lifted the shadow from my uncle, Jack, as I called him. And that, of course, that strange body was the High Court of Australia, on which I was later to serve. And the High Court effectively said that in this country there's tons of power to deal with anything that the commos do, but for what they think and what they believe, the law doesn't permit the federal parliament to intrude into that space. That is their business. But when they do things, that's when you can nab them. And that was a very important instruction from the High Court. I think it's one of the greatest decisions of the High Court myself. And then the people of Australia, in a referendum which followed within a year, refused to change the Constitution and refused to allow the Menzies government to put the bill through the Parliament once again. And that really taught me how we live in a society which accommodates difference and allows people to have different points of view, including very unpopular points of view. The communists were like the terrorists back in those days, and their views, political organisation, the churches disliked them, and many people in society. The polls showed that 80% of the people of Australia supported the bill. And you have to ask yourself, would any politician today fight a measure if there was a consistent 80% support for it? They really had courage to fight it and to beat it, and it affected the whole pattern of our life in Australia as a tolerant, liberal community. And then a few years later, when I reached puberty, I learned that I was a sort of criminal, and that I was really ought to be thoroughly and completely and always ashamed of myself. Well, I didn't really feel very ashamed of myself, but that was what the law told you in those days, that if you were gay, you had to pull up your socks and really live a completely and totally celibate life. And if you didn't, you'd be nabbed by the police and you'd be rounded up and put in jail. And lots of people were, including very distinguished people, including distinguished visitors like the Chilean concert pianist Claudio Arrau, who was nabbed just down the road here at the Sydney Town Hall. So that wasn't a very nice discovery, and it taught me again that the law is probably generally all right, but it can become sometimes really very unfair and rather stupid and ignorant. Then I went to university and I became a student politician. I was the most successful student politician of my generation, and I got involved in the Aboriginal freedom rides. I defended the Aboriginal, the protesters, Aboriginal and other Australians who went up to Walgett to desegregate the cinema up there. As you know, Jim Spiegelman, later the Chief Justice of New South Wales, went to Moree in one of the freedom rides to Moree, and my job as a young lawyer was to defend these people and defend the Vietnam War protesters. I joined the Council for Civil Liberties, and my experience with the communist issue and the homosexual issue really made me rather sensitive to the fact that there was discrimination and unfairness out there in the community. I think everyone in this audience, whatever their views, should become engaged. I mean, it's really important for lawyers especially to be joiners, to join civil society, to make democracy work. Because that was another issue at the time I was growing up, white Australia. I mean, I grew up in white Australia. When I was at Fort Street in 1951 to 54, there were, I think, about 7 or 8 Asian Australians in the whole school. Now, of course, it's about 50% or 40% of the school, and that was because of the law. The law prohibited people migrating to Australia, even if they married an Australian overseas. They had tremendous trouble getting into Australia. We were a white enclave and we were entitled to keep our society as we were. We didn't want the hordes of Asia, that word that was always thrown out, coming down and swamping us, and we were entitled to and would defend our borders. That was the Australia I grew up in, disliking and rounding up the commos, really disliking the gays, not very nice to women, very big disadvantages for women, horrible to Asian Australians, and there weren't many of them, and in the Vietnamese War, going up there to liberate Vietnam, not very successfully. That taught me a lot of lessons about how transient attitudes need to be considered very carefully, and we've all got to be very alert to the issues of injustice and discrimination, treating people unequally for unreasonable grounds, for irrational grounds. And so that is what we're here at this session to talk about. Now, I want to talk very briefly about 3 subcategories of discrimination. The first is Aboriginal and Torres Strait Islanders, the Indigenous people. When I was at law school, I was taught the orthodox law that when the British flag was rung up at Circular Quay and Governor Phillip took control of first half of the continent and later the rest of it was taken control of in the name of the Crown, that expelled the Aboriginal law, because essentially the Aboriginals were nomadic, uncivilised people who wandered around, didn't have a real legal system, and therefore there was no need for the British to recognise, respect and protect that legal system. And that was the orthodoxy that was part of our property law, but also part of our general attitude to the Aboriginal people. And then in 1967, as you know, there was the big referendum which was designed to take out of a provision of the Constitution, section 5126, a limitation on the enactment of laws with respect to people of any race. It then had comma other than the Aboriginal race, and those words of exclusion of the power were taken out of the racial ground. That's left us with a provision in our Constitution that permits the Federal Parliament to make laws for the people of any race in respect of whom it is necessary to make special laws. And I am sure from the reading of the referendum campaign, from my own recollection, from the reading of the Hansard at the time, and the great campaign of W.C. Wentworth MP at the time, that the object of the exercise was to remove that exclusion so that beneficial laws could be made in respect of Aboriginal people. And the question arose twice in my time on the High Court of Australia as to whether the word for people of any race meant for the benefit of or simply meant in respect of. I took a view, which didn't prevail, in a case called Cartinieri, and Justice Gordon indicated her general agreement, that for meant for the benefit of. But the majority held, and it is the law, that for the people of any race merely means in respect of the law, the people of any race. And that being the case, the race's power can be used to make laws beneficial to the Aboriginal people of Australia, but also very prejudicial to the people of Australia, Aboriginal people, and prejudicial on the grounds of their race. And essentially, in the Northern Territory, the Northern Territory intervention is a law for the Aboriginal people. It's propounded to be one for their advantage, but it's a law which chooses race as a criterion and makes a law which imposes on the Aboriginal people there restrictions and limitations which, if they were done to Greek Australians or to Chinese Australians or to Irish Australians, it would be an outrage. It's so 19th century to have a race's power in the Constitution. Can anyone name any other constitution in the world that gives power to its national legislature to enact laws with respect to people by reference to their race? It really is fixed in a 19th century notion of racial determinism, that your race fixes you and requires special treatment, including by the law. My very last decision in the High Court of Australia was in the case of Wurrajil against the Commonwealth, in which the laws on the intervention were challenged. Sadly, I was in a minority of 6-1. But in the course of my reasons, I said that if a law was enacted with respect to any other racial community, to make laws with respect to them by reference to their race, it would be a scandal. Chief Justice French said in his reasons that was a gratuitous comment. And I responded, it wasn't gratuitous, it was absolutely central to my reasoning. But this is a very unpleasant provision of our Constitution, and we have now the report of the committee which was being established to try to suggest reform of our Constitution, but whether we'll ever get anything through the current very bitterly divided political scene in Australia is a big question mark. So that's the first thing. Secondly, in the High Court and Justice Wilcox and Justice Lindgren in the Federal Court, a big part of our diet was the area of refugee law, and a very large number of the cases, indeed it threatened at one stage to swamp the High Court, so the court changed its procedures for special leave applications in order to allow cases to be dealt with, routine cases to be dealt with on the papers, instead of giving everybody 20 minutes. In the end, we were in this situation that if we gave everybody in this category 20 minutes, we would have no time to do anything else. And so we had to allow for provision on the papers, and that is still the case in the High Court. Since my departure from the High Court, I've noted and read with eager anticipation some of the decisions of the High Court, including in the Malaysian solution, the so-called Malaysian solution case, where the court has been taking, I think, with respect, a very admirable and strong line concerning the position of refugees. Can it possibly be conformable to our duties under the Refugees Convention and Protocol, which promises that we will give asylum to people who have a well-founded fear of persecution if they are returned to their country of nationality? Can it possibly be consistent with that when they come sailing across the seas towards us, upsetting thereby the tabloid media and thereby the many citizens of this country, that you can somehow divert the ships and turn them round and send them somewhere else when you've promised to give protection and send it to some other place in order that someone else can consider it and make it someone else's problem? This is something which I think Australia is going to have to really reflect upon, its legal and moral obligations. And I have to pay a tribute to the legal profession, because the legal profession really came to great assistance by pro bono assistance to many, many people in this situation, and all of us who are boat people. Almost everyone in this room is eventually a boat person of some kind who's come to this country either on sea-borne boats or on airborne boats. All of us except the Indigenous people are boat people, modern boat people, and we keep singing in our anthem for those that come across the seas with boundless plains to share. Well, we have a trickle in comparison to countries of Europe, and at its heart the resistance to it and the fear of it is a xenophobic fear to a trickle of people, and we've got to help ourselves to get over it. Now, the third category I want to speak of relates to sexuality. And when I first heard about the idea of same-sex marriage, I must admit that because I'm a lawyer, I sort of had mental blinkers. There was a case in New Zealand which went to the Court of Appeal of New Zealand. It's called Quilter against the Attorney General of New Zealand. And a lesbian couple in Napier went to the local marriage registrar, and they wanted a marriage certificate. And you can imagine the local registrar in Napier was a little bit surprised about this and ultimately said no. And then they went to the courts, and they went to the Court of Appeal of New Zealand. And in the Court of Appeal, the court had two questions to answer. One, is the denial of a marriage certificate to this couple of New Zealand citizens, is this necessary, or could you construe the right to a marriage certificate, the right to be married, which was expressed in the Act in terms of a person, could you construe that as available to people of either sex, either opposite sex or same sex? The argument against was that in the 19th century, a judge in England, in a case called Hyde against Hyde, which was concerned with Mormon marriages, said that a marriage in the English common law is a marriage between a man and a woman to each other, to the exclusion of all others, for life. And so the judges of the Court of Appeal said unanimously, they said, no, you can't interpret the Act to read it differentially. That's the background against which it was enacted, and that is the law of New Zealand. But then there was a second question, and the second question was, in that event, was there discrimination under the Bill of Rights Act of New Zealand, which should be drawn to the notice of the Parliament of New Zealand so that the Parliament of New Zealand can consider whether it wants to reform the Act. That was the scheme of the New Zealand Bill of Rights Act. And in that respect, it was the foundation of what later became the scheme of the British Human Rights Act and of the Victorian and ACT Human Rights Acts, that Parliament gets a chance to look at it. The courts don't get a chance to strike down legislation that's incompatible, but they do get a chance to call it to notice. The idea being to activate our democracy to make Parliament address what a court has found to be discrimination. And 4 of the judges at the Court of Appeal in Quilter said, no, it's not discrimination. Marriage has ever been thus, and therefore there's no discrimination. But Justice Thomas, who has lately been knighted, in New Zealand, they, like our Order of Australia, they had a gong, and the new government of New Zealand, the key government, allowed all the people who got the top gong to convert it to a knighthood. And of the 89 who'd got the top gong, like a companion of the Order of Australia, you'll be very surprised to hear that 87 of them asked to convert it to a knighthood. It's amazing, isn't it, how that happens? Anyway, Sir Edmund Thomas, he at the time wrote his opinion and said, of course it's discriminatory. This is a law of the Parliament of New Zealand. It's a civil law. The Parliament is secular. These are citizens. They want to get married. The Bill of Rights Act forbids discrimination on the ground of sexual orientation. This is discrimination on the ground of sexual orientation, and therefore this is discriminatory, and it should be drawn to the notice of Parliament. Parliament can do what it wants, but it is discriminatory, and Parliament should have the discrimination drawn to their notice. Now, when I first heard of that case, I thought, poor old Ted. Ted's losing his marbles. Of course it's not discriminatory. Marriage has ever been thus. But, the intervening 12 or 13, 14 years has demonstrated that actually he had the insight. He could see that there was discrimination, and whether Parliament wanted to do anything about it was Parliament's business. But what others didn't see, including myself as a gay man, then in a relationship of 30 years, now in a relationship of 43 years, that I didn't see that was discrimination, is an indication of how we lawyers get our blinkers put on. We get blinkers put on, and it takes people with a special sight to see the need to remove the blinkers, as it took people with a special sight to see the blinkers with communists, with Asian Australians, with Aboriginal Australians, with other people of colour coming to Australia, and people discriminated against on the ground of age, on the grounds of gender, and so on. You need people with a special sight. And the object of our session today is to help us all to have a special sight. Now, not all of us will agree about the issue of marriage equality, as gay people prefer to call it, marriage equality. But over the years, I've come round to seeing the points of view that Justice Thomas expressed. Nobody's suggesting that marriage should be compulsory. And a lot of people nowadays, straight and gay, don't get married. Gays can't and straights don't. Secondly, marriage can be a sacrament in a church or a temple, but it doesn't have to be. And in Australia, apparently, I'm told that 2/3 of young people today don't get married in a church. And therefore, for them, it's not a sacramental matter, it's a legal matter. Thirdly, in Europe, they never confused the sacramental with the civil. As you may know, in Europe, if you get married in the Netherlands, for example, or in France, you go to the town hall or the registry office. You get married. And then you, if you want to, you go tippy-toeing down the cobbled streets to a church, and you can have a ceremony of wedding in the church. But the two are separated. Napoleon separated them. And that's how it is in most countries of the world. It's in the British countries that we've sort of jumbled the two up and given the power to the churches to perform the civil function of marriage. Thirdly, the rights and duties are provided by law. It's a civil right and civil duties. It's made by the law of the land. Fourthly, our parliament is a secular parliament, or at least that's what we'd say, and section 116 of the Constitution at least says something about the fact that the assumption of the Australian Commonwealth is to be a secular community where your religion is a private matter and not something which is part of the functions of the state. Fourthly, marriage, it is said, is for children, and of course it is, and it's very important that marriage should be there for children, but it's not only about that. I don't know if you saw it, but the Duchess of Alva, you'll be very pleased to hear, got married the other day in Spain, and she was 85. I think it's somewhat unlikely, though miracles can happen, especially in Spain. It's possible that she might give birth to dear little children, the Viscount of Alva, but rather unlikely, though her partner is a very young man. You never know what might happen. But marriage can and often is blessed with children. I grew up in a firmly heterosexual marriage with my parents, and it was a great blessing. But there are plenty of other people who don't have children and don't want children, including straight people who don't necessarily get married to have children. And then it's finally said that growing up with two gay people is very harmful to children, that they must have an image of a man and a woman. And I'm not against the image of a man and a woman. I had that all my life and it was wonderful. But nowadays we know in the law that the big problem is serial single parent families. It's not two parents, it's people trying to bring up a child on their own. And my understanding is that all the research has shown that there is no harm whatsoever to people who grow up with loving parents. The main thing is loving parents. If you have love, you have the solution, and you are a lucky human being. And the onus is on those who want to show that there is real harm to children to show it. In my own small experience of knowing mostly gay men who've been bringing up the child of one of them who spent some early time in a marriage with a woman, the child grows up A, robustly heterosexual, and B, very powerfully supportive of the parents, and C, knowing love, a rounded human being. I don't know how many of you saw that thing on YouTube of the person who appeared, I think it was before the legislature in New Jersey, in which he said, I was brought up by my parents and they were two women, and I'm outraged that you are denying them their right to be married. So we're going to see a lot of debates about this, and it'd be interesting to hear your points of view about it. And we can have a talk about any of the issues I've mentioned. And now is the hour. This is the time for Q&A. There is, as you know, in quite a lot of discrimination acts, discrimination on the ground of marriage status. And therefore, there would be cases in relation to discrimination against people on the basis of their marriage status, either being married or being unmarried. And that would be the subject of reports and of decisions of commissioners and of tribunals. And I would suggest you have I don't know of it myself, but it is a category. Yes. Yes, of course. No, exactly. And but they're not necessarily incompatible. Out there, shining in the distance, is a But anyway, the long and short of it is it is a category, it's correctly a category, and if there are discriminations against it, then it is one that should have remedies. But I'm not familiar with that territory at all. In fact, I'm not particularly familiar with any of the categories. We had cases in the High Court on age. That was the pilot's case. We had one on disability. We had one on gender, and we had a couple on sexuality, but it's not a big part of the work of the High Court of Australia. We had some in the Court of Appeal, and one of them was the famous case of Gubbins against Qantas. And Gubbins was on the ground of gender. Qantas tried to dismiss all hosties over the, as they were called then, over the age of, I think it was 45 or 50, and came up to the Court of Appeal, and Sir Lawrence Street I was sitting fortunately with Sir Lawrence Street, who was always, because his mother was Jessie Street, he was always sensitive to gender discrimination, and we upheld the right of the hosties. And very interestingly, about 5 years ago, I got an email from Miss Gubbins, and she said, we have an annual get-together and we all talked about it and we'd love you to come along to the get-together. And we are the golden oldies of Qantas, though I'm still working for Qantas. And I said, well, I don't know, would that be correct? But by the time I became an ex-judge, I thought, oh, well, hang it. It doesn't matter if I go along, nothing can come of it. And I'm going to be there on Monday night at the Wentworth Hotel for the Golden Oldies. That was a good decision. They also invite along Justice Baston of the Court of Appeal, who was their counsel, who won the case. These are important decisions where standards are set and companies and departments have to, in our law system, have to conform. Yes.
Your Honour, it is as ever a privilege to hear from you. If I could ask you one question in the realm of disability discrimination, in particular the deaf and access to justice, and invite you to retell the story of Gradage and Grace Brothers. Of which? Gradage and Grace Brothers.
Yes. Oh, well, Gradage, yes, I know that case. Well, do you want me to tell the story or would you tell the story?
No, please tell the story.
Well, in Gradage, Mrs Gradage had a compo claim in the Workers' Compensation Commission, and she was mute, and therefore she couldn't speak or hear without the assistance of signage. And so the case was going along in its boring old way, as we lawyers know cases do, and she was, and then, I object! And this was the lawyer for the insurance company, and the lawyer for the insurance company got on his feet and said, Your Honour, my objection is, and then he saw the interpreter was continuing. He said, Your Honour, this is just a matter of law, and I would be grateful if there's no need for the interpretation. So the interpretation, yes, madam, you can cease interpreting. This is just a matter of law between us from the bar table and the court. So the judge nodded, and then the argument went on, and he saw out of the corner of his eye that the interpreter was continuing to interpret. And the judge said, Madam, I said there's no need to interpret this, and she interpreted that. And, and the judge then went back to the argument, and then he saw that she was... And this was a very good judge, very good judge. He was a bit of a mentor for me, showing that all of us can make mistakes. And so she kept interpreting, and he said, Madam, if you will continue to disobey my instruction, I am not going on with this case, and the court will adjourn. And he jumped up and walked out of court, and they came straight away to the Court of Appeal. Now, I don't know what the Court of Appeal is like now, but in my days it was touchy-feely, and everybody could come straight away, and if it's a very urgent matter. And so they said, this judge has stopped hearing, and these are the facts. So I said, well, what's the law on this? And then went to a case called iCLE against dairy farmers in the High Court, where the High Court, with its usual Delphic assistance, said that the decision on whether an interpreter is necessary is a matter that is particular to each case and must be left in the discretion of the trial judge. So they said, you can't, this is the discretion of the trial judge, he's exercised his discretion, and it's a matter of practice and procedure. An appellate court will never intervene in such a matter, so leave it alone and go back, and then she won't interpret until the matter resumes, a matter of substance that concerns her. But none of us felt very happy about that. I had Justice Samuel sitting with me and Justice Clark, two very, very fine judges. So we went out and we looked at the statutes. Where is the Interpreter Right to Act? And there, you'll be amazed, there is no right to an Interpreter Act. And then we looked at the federal statute book, and we found the then Human Rights Commission Act, to which was annexed the International Covenant on Civil and Political Rights, though it wasn't incorporated as part of our law. But it did have in that covenant, next to the Commission Act, it had a provision that said anybody in a court of law is entitled to have the case in the language which they understand. And so we then agreed that the judge had breached the common law of Australia as informed by the general discretion and as clarified by reference to the ICCPR, and that decision was the one that we then gave unanimously in the Court of Appeal and sent it back to the judge, essentially affirming what the interpreter said, because her immortal answer to the judge when he said do not continue to interpret was a correct legal answer. Whilst I am in your honours court, and whilst your court is in open session, it is both my legal and moral duty to continue to interpret so that the applicant will understand and see the light of knowledge because of the case that's unfolding affecting her. All of that is reported in Graddage against Grace Brothers Limited, which is, I think, about 1989 in the federal law reports. It's not in the New South Wales law reports, but it's in the federal law reports, not federal court reports, federal law reports. Okay, anything else? It's probably in the federal law reports because it referred to the Human Rights Commission Act annexing the ICCPR. And anyway, that gave the editor enough reason to put it in the federal law reports. Yes?
I'm wondering if you could comment on the best way intersex people could be protected under these new laws, whether just on the grounds of gender identity, which I don't think is satisfactory, or whether we should be broadening the definition of sex or including perhaps an additional attribute of sex characteristics or intersex status.
But why should it not be a specific ground? Why should there not be, now that we know that there is a category of intersex people, why should there not be, to lay any doubt, why should they not, if they're going to consolidate their grounds, why not specifically mention it?
No, I think they should, but I think intersex people would like protection under the ground of sex in the same way that men and women are, and also protection under the ground of gender identity.
Yes, well, that raises an interesting question. In the Human Rights Committee, a question arose in Croom against Tasmania as to whether discrimination against homosexual people was discrimination on the ground of sex. And the Human Rights Committee rather suggested that it was. That hasn't, I think, yet been finally determined. And the other ground that was given in Croom was privacy, that people shouldn't have the state intruding in a private matter in their bedrooms, that's a right to privacy issue, or equality, that people should be treated equally as citizens, irrespective of what their sexual orientation or sexual identity is. So that there are a couple of categories there, and I think this area of the law is still working its way through, and that shouldn't be surprising. As the Secretary-General of the United Nations, Ban Ki-moon, said only last week before the Human Rights Council, when it was debating the issue of sexuality and sexual identity, he said, when I was growing up, no one talked about these things. But now we know more, and therefore we have to talk about them. And though there are cultural and religious sensitivities to it, which I understand, the Universal Declaration of Human Rights is entirely clear that human rights, universal rights, belong to everybody and are not to be withdrawn from some people either on the ground of their sexuality or their sexual identity. It was a very strong statement. If you can get a chance to see it on the internet, it's truly remarkable that this ex-diplomat, ex-bureaucrat in the United Nations from Republic of Korea, who probably had a Methodist upbringing, I'm not sure, maybe a Confucian one, but he is now absolutely clear. The result of it was that a number of Islamic delegations and a number of African delegations walked out. So that there will be a lot of tears, sweat and toil before all of this is sorted out. But if you think about the changes that have happened in the last 30 years, 20 years, 12 years since Quinlan, a lot of change has happened. And partly I think that's happened because people like me have become more honest about it. When people didn't ever know any gay people, they could imagine all sorts of horrors and so on. And there are some horrors out there. Some gay people are horrible. Some straight people are horrible. It's boring, but, you know, there are people everywhere who are horrible. And there are people who are sweet and wonderful. And therefore, we've got to get over it and have an aspirin, a lie down, and get on with it. Anyone else? Any other questions? Yes?
Hello. Hi. It's an absolute pleasure hearing from you, sir. I can tell you're like the James Bond of the law world for us, for us lawyers. My question was on Indigenous discrimination. It seems if you look at policy, it's always dichotomised into either intervention or self-determination. And in both areas, there seems to be inherent flaws. So as a young person, what do you think? What more needs to be done?
I'm not entirely sure. Are you talking about self-determination?
Yes.
Of peoples?
Of Aboriginal people, yes.
Yes. Well, as you know, the common first article to the two international covenants, it's both in the ICCPR and in the International Covenant on Economic, Social and Cultural Rights, is a statement that peoples have the right to self-determination. And that gets a lot of people in countries like Australia very agitated because they perhaps naturally think self-determination means they're going to have a big vote, they're going to opt out of Australia, they're going to succeed, and that won't work because they're in Redfern and you can't have a sort of Pimlico at Redfern where there's a border and you've got to have a visa. So people don't like that idea. But self-determination doesn't necessarily mean political severance. Self-determination means that either in your own separate polity, as East Timor, for example, now is, or within another polity, you have a big say in what affects the governance and integrity of that people. And as I understand it, that is what the Aboriginal people in Australia are claiming, and it's what the Convention on the Rights of the Indigenous Person respects, that you are recognised as a people and that you have the rights to dignity and those things which are essential to your continuance as a people. A controversy arises as to who is a people for the people's right to self-determination. And I chaired a UNESCO expert group towards a description of who a people are for that. We didn't call it the definition because it was a preliminary work, and it's still a controversial question in international law. And the criteria we found and expressed were that it has to be numerous, that it's not a club. We're talking about a people for international law purposes. It has to be a people with institutions that give effect to their peoplehood and a way of expressing their peoplehood. And thirdly, that there has to be the will on the part of that group of human beings exhibited as that they want to be a people for international law purposes. And if you apply those criteria, then the Aboriginal people are numerous. They do have institutions, some of which have been created by our Parliament and some of which pre-existed. And thirdly, there's no doubt that many of them, probably most Aboriginal, have a will to be seen as Aboriginal and Indigenous people and respected as such. So on those criteria which the UNESCO committee adopted, they would qualify as a people for self-determination. But that doesn't mean that they're going to go off and be an entirely separate political nation. It just means that they will have certain matters that are left to them and on which they will be consulted and engaged. And won't have laws plonked on them by reference to their race. A very 19th century idea. Yes?
Does human rights uphold consenting adults in polygamous relationships?
The acoustics in this room were, I think, designed for those who speak from the pulpit and not so good from those who speak up.
Does human
like most churches. Bit better, yes.
Would human rights uphold consenting polygamous relationships who want their relationships recognised as marriage on the basis of quality? Would that be seen to be marriage as well? And likewise, say, to consenting 14-year-olds who want their consenting relationship to be recognised as marriage, could they mount that also on the basis of discrimination to be marriage?
Well, I think it's very unlikely that a parliament in Australia would provide for either, but there is no doubt that polygamous relationships are recognised in many countries. Most Islamic countries recognise polygamous relationships. And I imagine the state of... where did the Mormons come from? Utah. That, I don't think it does now, but I think it probably originally did have recognition, and I think Mr Romney is safely single married.
On the matter of, we're arguing about equality and human rights and to treat people equally, where there's consensual relationships.
Well, it may be that someday we do recognise polygamous relationships. I don't think that's likely in Australia. I don't think it's any time soon. And as for 14-year-olds, it's an interesting thing. If you actually look at the criminal statutes of different countries, of what age people have to be, there's no common agreement on what that should be. In Spain and Portugal, it's 12. And in some countries, like Saudi Arabia, it's 21. And so we have hit upon different ages for different things. For example, 16 for consent to sex, and I think in the international sphere, the sex tourism, it's 18. So it's different. But I don't think you need to worry your head about these things. These are not real issues. If we're talking about marriage equality, we're talking about approximately 4 or 5% of the whole population, and there aren't 4 or 5% of the population who either want to be married to a number of wives or husbands, or who are seeking the rights of 14-year-olds or 12-year-olds to get married in this country. It's not on. And therefore we're talking about what we're talking about, which is the right of adults. Take an adult like me, a very ancient adult, 73, 43 years. Anybody who tells me that I do not have a right to my relationship with my partner who is at home now grouting the swimming pool and who will be there tonight. The issue is not property, the issue is not even reputation. The issue is kindliness and love and tenderness and touching, and somebody who's there and cares whether you're living or dead. And on that criteria, I think it calls for a certain kindness on the part of our community, and sadly it isn't always evident. And the saddest thing for me is it's often not evident in the churches, which I think should be the very centre of kindness, being the essence of the religion I was brought up in. Okay, I see Luke. Luke is here. Don't forget the book.
Would you mind signing a couple of copies if people have them?
Yeah, of course, I'll sign anything. I'll sign anything but a cheque.
Well, I made 2 promises, Michael. One was to you for a sandwich, so while we get that from the fridge, Michael has kindly agreed. I also made a promise to one of our lawyers, Amelia, that I would get Michael Kirby to sign her book. Well, his book, rather. So she's going to dig that out of her handbag. Anyone else who has copies of Michael's book, he'll kindly just stand, I guess, at this table here. We have a special guest who's come to see us today, who's just going to come up now while I thank Michael.
Yes.
Judge, Your Honour, that was a very personal and very powerful
Is it as good
lecture.
as the first one?
I think the passage of time has made it difficult to compare, but both are very firmly...
You're not forgetting.
Both are very firmly in my mind, and one is now in print. But it was a pleasure on that occasion, and I thank you on that occasion for persevering, because it was very important to me that you came on that day, and everyone who attended on that day some years ago was very grateful for you then. No doubt everyone who is here today is equally grateful for the contribution you've given, not only today but over your many years of service. I commented earlier on His Honour's, very briefly because I'm sure it is all known to many of you.
You can go through it again.
His Honour was, is it the longest serving or one of?
No, when I retired, I was the longest serving, but...
The longest serving judicial member and the youngest appointed to the Federal Court. Your Honour talked about age and perceptions and discrimination, and no doubt those years ago you may have been perceived as a young upstart. Now, very far from that, someone called you James Bond. Judge, as our special thanks to you, we've given to each of our other presenters today a copy of a book of our own, and I have signed this one. It may not be as valuable as your signature, but who knows in 30 or 40 years' time. The book is a collection of our stories of transformation of some of our clients here at Salvos Legal Humanitarian. Stories of real people, real facts, real cases, no embellishment. We've changed the names and some personal identifiers, but otherwise the cases are very real. Also inside the book, and it's funny when I read what it is, it's not a gift for you, it's a gift from you. It's some goats for a developing family. And there's a picture, for those of you obviously who can't see it, some very cute goats. And the words, however, say goats provide milk, which is no surprise, but meat to families and income through the sale of kids. So hopefully yours will provide more milk than meat.
Not so keen on the meat.
More milk than meat, Your Honour. But yes, Your Honour...
They look a bit like some lawyers I've known.
The other thing I wanted to share, Your Honour, is because of your contribution to this lecture series and our other presenters, I've got a bit of a rough total of some of the money that has been raised today. The money that each of you have given, and if those of you have not yet had an opportunity, there's still people out the front. The money from today and in the lead up to today goes to fund disbursements for our clients. We don't rely on legal aid funding for disbursements. We don't ask our clients to pay because the ones that we act for free have no capacity to. We use the lecture series here on this occasion and on one of the previous occasions to set up what we call a war chest. The war chest is there to pay for filing fees because many federal jurisdictions no longer completely waive them, to pay for appeal book preparation, for doctors' reports, medical reports, psych reports, all those sorts of hard disbursements that need to be paid in order that people who don't otherwise have the resources can compete with those who are against them in court cases. So today our rough balance at the moment is about $14,000. So congratulations and thank you to you all for that. The money will help many people in need. The other thing I wanted to share with you is His Honour's lecture. You cannot quote me on this, but Rule 176, or rather Clause 176 of the Legal Profession Regulation refers to the requirement for solicitors every 3 years to undertake 1 hour in an area of discrimination, equal opportunity, OH&S and workplace relations. The oral advice we've received from the Law Society is that this lecture will cover that if anyone was seeking it. However, they refused to put it in writing and said that lawyers need to rely on self-disclosure when they sign their renewal each year. So I'm going to be signing it for my own sake. What you choose to do is a matter for you. But it was nonetheless, whether valuable in terms of points or not, a very informative and very deliberately and carefully prepared and entertaining and structured lecture. So thank you, Your Honour.
Thank you.